नमस्कार दोस्तों, कंपनी लॉ एजुडिकेशन एंड अपील सीरीज में आपका स्वागत है। आज हम लोग देखते हैं दिल्ली आरओसी का एजुडिकेशन ऑर्डर फॉर द वायलेशन ऑफ द सेक्शन 92 एंड सेक्शन 137 ऑफ द कंपनीज एक्ट इन द मैटर ऑफ द एस्ट्रो ऑटो एंसिलरीज प्राइवेट लिमिटेड। ये आज से पब्लिश हुआ है। ये ऐसे एजुडिकेशन ऑर्डर डेटेड 25 फरवरी 2022 को पास है। इस केस में कंपनी का नाम है एस्ट्रो ऑटो एंसिलरीज प्राइवेट लिमिटेड, जो दिल्ली में रजिस्टर्ड कंपनी है। और इसके जो डिटेल्स है, इसमें पेड अप कैपिटल कंपनी का 11,11,250 है। फैक्ट्स ऑफ द केस ये है कि रिफर टू द एजुडिकेशन एप्लीकेशन फाइल बाय द एप्लीकेंट, जिसमें कंपनी और डायरेक्टर है, उन्होंने इसको फाइल किया था इन फॉर्म GNL 1 dated 30th November 2021, which is approved on the 3rd December 2021 under the provision of section 454 of the Companies Act and rules made thereunder for the non-compliances of section 92 subsection 1 subsection 4 and subsection 1 of section 137 of the Act. The company could not file its AOC 4 and MGT 7 for the financial year ended 31st March 2020 as its AGM could not be held in time. That after holding AGM on the 6th September 2021, the company has filed its due document E-Form MGT 7A for the financial year ended 31st March 2020 on 13th September 2021 and financial statement and E-Form AOC 4 for the financial year ended 31st March 2020 on 13th September 2021 and thus made good the default. A reasonable opportunity of being heard was given to the applicant by issuing hearing notice dated 19th January 2022. A date of the hearing was fixed on the 8th February and its authorized representative attended the hearing and gave oral submission and necessary document. Copy of the challan company and that company has rectified such default by filing its document. The relevant provision of section 92 and 137 as per section 92 subsection 4, every company shall file with a registrar a copy of the annual return within 60 days from the date of the AGM is held, or where no AGM is held in any year within 60 days from the date on which AGM should have been held, together with the statement specifying the reason for not holding the AGM with such additional fees. If company fails to file its annual return as per subsection 4 before the expiry of the period as specified therein, the company and every officer who is in default shall be liable to penalty of 50,000 rupees, and in case continuing a failure with a further penalty of 100 rupees for each day after the first during which the such failure continues, subject to maximum 5 lakh rupees. Further, subsection 5 says if a company fails to file its annual return as per under subsection 4 before the expiry of the period as specified therein, such company and every officer in default who is default shall be liable to penalty of 10,000 rupees in case of continuing failure, with a further penalty of the 100 rupees for each day after the first during which such failure continues, subject to maximum of the 2 lakh rupees in case of company and 50,000 rupees in case of officer who is default. Further, as per section 137 subsection 3, if a company fails to file the copy of the financial statement before the expiry of the period as specified therein, the company shall be liable to penalty of 1,000 rupees for every day during which the failure continues, but which shall not be more than 10 lakh rupees, and the MD, CFO of the company, if any, and in the absence of the MD and CFO, any other director who is charged by the board with the responsibility of the complying the provision of this Act. And in absence of any such director, all the director of the company shall be liable to penalty of 1 lakh rupees. And in case of continuing failure, 100 rupees for each day after the first during which such failure continues, subject to maximum of the 5 lakh rupees. Subsection 3 of subsection 137 got amended with effect from 21st February 2020, which now read as follows. This is very important. If a company fails to file the copy of the financial statement under subsection 1 or subsection 2, as the case may be, before expiry of the period specified therein, the company shall be liable to penalty of 10,000 rupees, and in case of continuing failure, with a further penalty of 100 rupees for each day during which such failure continues, subject to maximum of 2 lakh rupees. And MD, CFO of the company, if any, and in the absence of the MD and CFO, any other director who is charged by the board but responsibility of the complying the provision of this section, and in absence of any such director, all the director of the company shall be liable to penalty of the 10,000 rupees, and in case of continuing failure, with further penalty of 100 rupees for each day after the first during which the such continues, subject to maximum of 50,000 rupees. Adjudication penalty. In the present matter, there has been considerably a delay in the filing of the financial statement and annual return for the financial year 2020. Ended 31st March 2020. However, wide Companies Amendment Act 2020, following proviso has been added to subsection 3 of section 454. This is important because as per this proviso inserted in section 454, in case of the default relate to non-compliance of subsection 4 of section 92 or subsection 1 or subsection 2 of section 137, and such default has been rectified either prior to or within 30 days of the issue of the notice by the adjudicating officer, no penalty shall be imposed in this regard, and all proceeding under this section in regard to such default shall be deemed to have been concluded. On account of the above amendment, since the company has already rectified its default under section 92 as well as section 137, before the notice dated 19 January 2022, the penalty proceeding could be deemed to have been concluded. The matter is accordingly disposed of with no penalty. This is the copy of the order. Since there is no penalty case, the even option is provided for the appeal. This note gives importance here. Thank you so much for watching this update.